This courtroom moment starts quietly, but don't let that fool you. What you're about to witness is a complete collapse of two probation cases that were supposed to be second chances. The defendant here isn't facing just one violation. He's staring down multiple positive drug tests, repeated violations, and a judge who already has the paperwork in hand. This is a deferred probation case, which means everything hinges on one thing: compliance. And once that breaks, the consequences come fast. What makes this case intense is not just the number of violations, it's how clearly documented they are: dates, drug types, repeated admissions, and most importantly, the defendant pleads true to every single count. That choice alone removes most offenses and places sentencing squarely in the judge's discretion. We'll see how probation meant to keep someone out of prison turns into a direct pipeline straight back in. Stay with us, because what starts as routine courtroom procedure quickly turns into a hard lesson about accountability, probation rules, and what happens when the system decides it's given enough chances. Watch closely. This case moves fast, and the consequences move even faster.
Good morning. Are you Byron Dequer? Will your client waive the formal reading of the motion in each case?
He will, Your Honor.
Give me just a second to put this.
We can narrow down some of the counts.
I cannot hear you.
We can narrow down some of the counts on the M2LP.
Okay.
There's like 13 counts.
What do you want to go forward on?
We'll go for first 7.
Okay. State's going to proceed on 1 through 7 in each case. Okay. And Mr. Dequer, in cause number 23, DCCR 1448, I have a motion to revoke your unadjudicated probation. Shows that you were placed on.
This moment is critical to understand legally. The judge confirms that both cases involve 10-year deferred adjudication probation for assault on a peace officer, a serious second-degree felony in Texas. Deferred adjudication is not a conviction, but it's also not freedom. It's a legal tightrope. One misstep allows the court to revoke probation and enter a guilty finding immediately. No jury trial required. Here's where the defendant's situation becomes extremely fragile. The state narrows the motion to revoke down to counts 1 through 7, and the defendant pleads true to every allegation. In legal terms, that's essentially conceding the case. When someone admits the violations voluntarily, the judge no longer has to determine whether they occurred. The only question left is punishment. This is why defense attorneys often fight hard against pleading true unless there's a negotiated deal. Once you say true, the courtroom dynamic shifts instantly. The judge now holds all the leverage, and the outcome becomes largely procedural rather than contested.
Probation July 2nd of 2024 for the second-degree felony offense of assault on a peace officer, and that was a 10-year deferred probation. Is that correct? Yeah, it's just correct that you were placed on probation on that day, right? Are they printing? Huh? I feel like yours is closer, but it takes longer to print than mine. Do we need a new print? What do we need to do? Everything? We need a new TV. We need a new printer. We need new computers.
Thank goodness it's Christmas.
We need new tablets.
Just ask Santa.
Unfortunately, Santa is on the 4th floor of the old courthouse, and I missed that opportunity during budget season to ask for all this extra stuff. Okay. Okay, now, in cause number 23, DCCR 1449, I also have a motion to revoke your unadjudicated probation. This one also shows you were placed on probation July 2nd of 2024 for that same offense, assault on a peace officer, second-degree felony, and that was also a deferred probation for 10 years. Is that correct? Each of these cases allege that you violated your probation, and the state has elected to proceed in counts 1 through 7 in each. Count 1 in each case alleges that you provided a urine sample July 14th of 2025 that tested positive for methamphetamines. And is that true or not true? Count 2 in each case alleges that you provided a urine sample August 12th of 2025 that also tested positive for methamphetamines and amphetamines. Is that true or not true? Count 3 in each case alleges that you provided a urine sample August 25th of 2025 that also tested positive for methamphetamines and amphetamines. Is that true or not true? Count 4 in each case alleges that you tested positive August 26th of 2025 for methamphetamines and amphetamines. Is that true or not true?
True.
Count 5 in each case alleges that you tested positive September 10th of 2025 for amphetamines, methamphetamines, and ecstasy. And is that true or not true?
True.
Count 6 in each case.
What we're seeing here isn't a single bad decision. It's a pattern of repeated violations over time, and courts take patterns very seriously. Multiple positive drug tests spread across different months show ongoing behavior, not a momentary relapse. Methamphetamine, amphetamines, ecstasy. Each test compounds the previous one, making leniency harder to justify. Probation conditions exist to measure compliance and effort. When someone continues testing positive, despite supervision, treatment options, and warnings, the court often interprets that as unwillingness or inability to comply. That's especially important in deferred adjudication cases, where the court already gave someone away to avoid a conviction entirely. Here's the key question for viewers. At what point does personal responsibility outweigh second chances? Should courts continue extending probation when the violations keep stacking up, or does public safety demand incarceration? Drop your thoughts in the comments, because this is where legal philosophy and real-world consequences collide.
Case alleges that you tested positive September 16th of 2025 for methamphetamines. Is that true or not true?
True.
And then count 7 in each case alleges that you failed to conduct yourself in a courteous and professional manner at all times when interacting with your probation officer, and that you were argumentative, raised your voice, and became verbally aggressive toward them. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily? And did you plead true to those counts because they're actually true?
True. Yes, ma'am.
I have here on the tablet some documents in each of your cases that have your signature on them that the state has marked as exhibit number 1. Before you signed those documents, did you go over them with Mr. Rojas? And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted. Is there any evidence that Mr. Dequer is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. In cause number 23, DCCR 1448, find sufficient evidence to find you guilty, and at this time, find you guilty. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 23, DCCR 1449, also find counts 1 through 7 true. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections.
This is the turning point. The judge formally finds the defendant guilty in both cases and sentences him to 5 years in prison for each, but orders the sentences to run concurrently. That detail matters. Concurrent sentences mean the time is served at the same time, not back to back. So instead of 10 years total, the defendant serves 5. However, make no mistake, this is still prison. Deferred probation is gone. The opportunity to avoid a felony conviction has vanished. The judge also confirms that the defendant waived his right to appeal as part of the agreement, which locks this outcome in place. The firearm admonishment is another long-term consequence many people overlook. Under Texas law, this conviction permanently restricts firearm possession, and violations can lead to new felony charges. This moment isn't just about punishment. It's about how one probation failure reshapes someone's legal future entirely.
You will receive credit on that sentence also for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you, in each of your cases, the trial court certification that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Right? Good luck to you, sir. You can go back with the bailiff. Taylon Douglas, Mr. Rojas, it's a sentencing.
Byron Douglas. Yeah, yeah, they know.
I get it.
He knows to bring him back over here.
All right, you're Taylon Douglas. And Mr. Douglas was previously in court, entered a plea of guilty to the third-degree felony offense of obstruction or retaliation. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have one.
I haven't.
Any additions or corrections?
No, Your Honor.
Only that, court is inclined to follow judge and certainly concur with clients.
In addition, I have received, and you guys should have been given copies of jail incident reports. Have you all reviewed those as well?
We have them.
I'm not, but I take your word for them.
Okay. You don't like to follow rules, do you?
I follow the rules.
You do? You've been following the rules since you've been in jail? Kinda. Okay. So, how have you not followed the rules?
I don't know, just whenever, I say like whenever I get disrespected or something like stuff,
Oh, so when they disrespect you,
I just,
why do you think you deserve their respect?
cause I don't do nothing to disrespect them.
You don't? You don't? Sitting on the countertops, not getting down. Looks like trying to smoke in the bathroom, working out when you're not supposed to be working out, lying about it, saying you're brushing your teeth, teasing and cutting up with and being disrespectful.
This exchange is raw, and intentionally so. The judge isn't just listing violations, she's exposing a mindset problem. Jail rules may seem minor to inmates, but in the court's eyes, they reflect discipline, impulse control, and respect for authority. When someone repeatedly breaks basic rules, it signals trouble for probation compliance later. What's striking here is the defendant's age, 19 years old, and the judge makes that central to her message. She draws a clear contrast between ordinary young adults and those who commit felonies. Freedom isn't automatic anymore. Structure replaces choice. Rules replace preference. This isn't humiliation. It's a warning. Judges often speak this directly when they believe someone is standing at a crossroads. The court is making it unmistakably clear. Grow up now or grow up in prison. Would this tough love approach motivate change or push someone further away from accountability? That's a question worth debating.
Talking about the officers act like a little kid. Taking food when you're not supposed to. Calling them some lovely names. B word, tell them they're white and ugly.
That's what they said. I said.
Mm-hmm.
I don't know. I don't remember.
You don't remember saying that? So here's the thing, Mr. How old are you?
19.
19. So you're now on a felony, or about to be, if I follow the agreement, which I don't have to do. You're about to be on a felony probation, where you have to follow rules whether you like them or not, because you've committed a felony offense. So you don't get to make all the decisions for yourself anymore, right?
Yes.
Other 19-year-olds who don't do this, they get to go to bed when they want, wake up when they want, eat what they want, work out when they want. You don't get to do those things anymore because you committed a felony offense. And if you continue to act like you've been acting and not follow the rules, however insignificant you think those rules are, you're going to end up right back in here, and you're going to end up going to prison for up to 10 years. Do you understand? So you have to make some mature decisions as a young person who's probably not ready to make those decisions. It's going to be a conscious effort and a decision on your part to either do it or not do it, right? What's going to happen if I follow this is you're going to go to ISF. ISF is a 90-day program that's intended to help you make better decisions. But let me tell you what can happen. Between now and the time that you go to ISF, you're going to be in jail. If I get an incident report, it's a violation of your probation. You could get revoked off your probation before you ever go to ISF. Do you understand? And it's happened. Ask them out there. I'm tired of you young people acting like you're acting at our jail. They're tired of it. These people are just going to do their jobs, trying to go home, go with their families, make a living, pay their bills, something that you hopefully will want to do at some point in your life. Instead, they got to go to jail and deal with this. The crap from you kids. But now you're an adult for these purposes. If you get to ISF and you don't make it through that program, or I get incident reports from ISF, they send me those, you're not going to get out. You're never going to see the light of day again. You're going to go to prison.
The ISF program, the Intermediate Sanction Facility, is not a free pass. It's structured, demanding, and zero tolerance for misconduct. The judge explains this with brutal clarity. Any violations before or during ISF can result in immediate revocation and prison time. No second negotiation. What's powerful here is the judge spelling out both futures. One path ends with dismissed charges and no felony conviction. The other ends with years behind bars. This is the justice system giving someone a final off-ramp before permanent consequences kick in. For viewers, this moment highlights how probation isn't leniency. It's responsibility under supervision. The opportunity exists, but only if behavior changes completely. So ask yourself, if you were 19 and standing here, would this speech scare you straight, or would it go in one ear and out the other?
It's that serious. Do you understand? Okay, so I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $500 fine, and you're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. Again, if you do everything you're supposed to, this is a great opportunity today. I don't want it to all be negative, because you have some very positive things. You don't have a felony conviction on your record. If you're a convicted felon, it changes your life in so many negative ways. You're not going to get certain jobs. If you want to go to trade schools or school or anything like that, or college, you're not going to be able to do certain things, live certain places, all of that. So you still have that opportunity. And if you get everything together and you follow the rules, at the end of your probation period, the case is dismissed. You will never have a felony conviction. This is the chance of your lifetime to change it and live like the rest of us live, okay? The other side, though, is if you violate any condition of probation, you'll be brought back into court. You'll be found guilty, so you would be a convicted felon. And then the punishment can be anywhere in that range from 2 years up to 10 years in prison. You understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Again, I know there's other people out there. There's other young people that are acting up. It's going to be up to you to say, I'm not doing it. I don't want to go to prison. All right? All right, you can go back with the bailiff. Yes, ma'am. Hold on a second.
Before he goes, Judge, in light of the fact that you are giving him an opportunity at the deferred on the felony in reviewing of his incident reports from the PSI himself and his juvenile history, which is quite extensive.
Yes.
It is my intention to proceed, obviously with a plea bargain offer on those misdemeanors, but I think it would be important, at least with several of them, to have those on his record so that if he is back, we kind of know what we're going to do then.
So you won't be able to go to ISF until you take care of those misdemeanors. They'll bring you over on a jail day to get those taken care of. Ms. Molfino will talk to that prosecutor. If you enter pleas on those, great. If you decide to go to trial, then you'll just have to wait to go to ISF until those take care of with the trial, okay? Also, I do want to make sure a condition of your probation is that you are not allowed to be in the possession of a firearm of any type. That means in a vehicle with anybody with a firearm. That means at a house where there are firearms. You are not allowed to be anywhere where there's firearms. If you're living somewhere where there's firearms, you either cannot live there or they have to have those out of the house or locked.
This courtroom session shows both sides of the justice system in action. One defendant exhausts probation opportunities and receives prison time after repeated violations. Another stands at the edge, given a rare chance to avoid a lifelong felony, but only through strict compliance and maturity. The judge's message is consistent throughout. Accountability determines outcomes. Deferred probation is not forgiveness. It's conditional trust. Break that trust repeatedly, and the system responds decisively. Honor it, and the law can still offer a future without permanent damage. If you found this case as intense and revealing as we did, hit that like button, share your thoughts in the comments, and subscribe to Audit the Courtroom for more real courtroom breakdowns, legal insight, and moments that show exactly how justice plays out in real life. We'll see you in the next case.